Some individuals are limited in their ability to enter into contracts. This video is going to discuss minors, mentally incapacitated persons, and intoxicated persons. It's important to note that in each of these individual circumstances, a contract may be void. That means that it is non-existent from the get-go, or it may be voidable. When a contract is voidable, that means that the party who is either a minor or incapacitated or intoxicated has the option to elect within a reasonable period of time whether to continue with the contract or to void it, to make the contract cease to exist. Let's look at each one of these instances in turn. In Alberta, minors have a limited ability to enter into contracts. The reason for this is to protect the youth, while adding in some exceptions that allow for businesses to do business with minors without worrying about a contract being avoided. For the contracts that a minor enters into that are voidable, the minor must elect to void the contract as soon as possible or as soon as they reach the age of majority. The reason for this is that a court may consider a contract to be affirmed if a minor has fulfilled their part of the obligations for a significant length of the term of the contract. Consider a 2-year cell phone contract. A minor is likely going to be considered to have affirmed the contract if they perform their end of the cell phone contract for 18 months of a 2-year contract. A minor is obligated to avoid the contract within a reasonable period of time. Now, avoiding the contract isn't a way to completely avoid one's obligations. Consider the 2-year cell phone contract again. If a minor elects to void the contract 2 months into its term, the minor will still be obligated to complete their end of the bargain for those 2 months. It's the future obligations that are no longer going to be imposed upon them. The law is slightly different with regards to mentally incapacitated people. The question when determining what to do when a mentally incapacitated person has purported to enter into a contract is to determine whether or not there is a court order. If there is a court order declaring a person to not have the capacity to enter into contracts, then every contract they enter into is considered void, regardless of whether or not the other party to the contract knew about the capacity or the order at all. The situation is different, however, when a mentally incapacitated person does not have a court order. The question will become whether or not the other party knew or had reasonable knowledge that the person was incapacitated at the time. These contracts are voidable if the other party should have known that the person was incapacitated at the time. If there was no reason for the other party to know or to suspect that a person was incapacitated, then the contract is not void or voidable at all, and the obligations signed up under it will be upheld, and the parties will be expected, including the person who is incapacitated, will be expected to perform their end of the bargain. The last circumstance I want to talk about when it comes to personal incapacity to contract is in the case of intoxicated persons. Now, I'm not just talking drunk people. This could be intoxication with regards to any sort of drug or other sort of mind-altering substance. In these situations, the law is not going to be particularly concerned with protection of the intoxicated person. So the test is not as stringent as it is with respect to minors and with respect to those who are mentally incapacitated. And the test is basically that the person, it must be so intoxicated that they can't appreciate what they're doing. They have to be not just tipsy, they have to be really drunk. The second thing is that the other party to the contract must have known that that individual is so incredibly incapacitated that they're so intoxicated they don't know what they're doing. Now, again, because the law is not as concerned with protecting super intoxicated people, the law requires that the election So once the person sobers up, they have an election, potentially the contract is voidable. That election must be made right away. So unlike minors, where they have some time, perhaps till they're 18, the election with respect to intoxicated persons must be made right away. This is not an avenue for a wait and see approach. So for instance, you have a person who enters into a contract for the purchase of shares and is incredibly intoxicated, and then rather than sobering up the next day and voiding the contract, decides to play the market and wait and see what the price of those shares will do. That is not going to be a situation in which the court will allow the contract to become void, or allow the innocent, albeit probably hungover person, choose to void the contract. You wait too long and you're not going to be able to.